Good day, everyone. Bonjour à tous. I am Lally Rementilla, the Managing Partner of Intellectual Property-Backed Financing at the Business Development Bank of Canada. The Business Development Bank of Canada has the distinct pleasure of introducing to you the next speaker, Mr. Vishal Amin, Head of IP Policy at Intel. Vishal holds a bachelor's degree in neuroscience from Johns Hopkins University and a law degree from Washington University in St. Louis. He is an experienced executive leader and a globally recognized expert in IP, trade, and tech law and policy. In 2017, he was nominated by the President and confirmed unanimously by the US Senate to serve as the White House Intellectual Property Enforcement Coordinator, or IP czar. In this key role, advocating for American innovation, he has represented the United States as an undersecretary level official, directing US IP diplomacy and leading trade and law enforcement delegations to advocate for American IP interests abroad. He also directed a legal and policy team, part of the National Economic Council, that advised the President and coordinated key policies among cabinet departments. He is the first Asian American to head a component agency of the Executive Office of the President. For nearly 20 years, Vishal has been at the center of federal intellectual policy law, and while serving as senior counsel on the House Judiciary Committee, he was the lead counsel for several bills, including the Defense Trade Secrets Act of 2016 and America Invents. During the course of serving in 2 presidential administrations and in Congress, he wrote and helped enact major legislation in nearly all areas of intellectual property law, shaping the United States' modern IP system to protect and grow entrepreneurship. So ladies and gentlemen, I bring to you Mr. Vishal Amin.
Thank you, Lally, for that introduction. Thank you all for inviting me to speak to you today. It's great to be with you in person in Montreal at IPEC 2023. And I thank our hosts, David Durand, and the International IP Forum Quebec, and all of you for the warm welcome at this important conference, designed to help businesses of all sizes navigate the complex world of intellectual property. In the US, our Constitution recognizes the fundamental importance of IP and its protection. Intellectual property underpins nearly every aspect of our economy. It supports good-paying jobs, it supports the arts, sciences, and technology, and it creates a framework that allows new industries and innovations to flourish. Globally, we need to be committed to protecting the IP of our companies and providing a level playing field for our workers. This September in the US will mark the 12th anniversary of the enactment of the America Invents Act. In October, we mark the 15th anniversary of the Pro-IP Act. Both pieces of legislation were significant, not only in their scope, but their impact on the innovation landscape and our laws. Back in the early 2000s, the US Congress was looking at a number of pressing IP issues impacting patents, copyrights, and trademarks. Congress was also looking at ways to better deal with the broader IP landscape. During that time period, while serving in the Bush administration, I drafted an executive order that could enhance our existing IP efforts and establish an IP enforcement coordinator, IPEC, within the White House, with appropriate authorities handling both domestic and international issues. But like all good ideas in Washington, that draft EO sat in my desk drawer for quite a while. During the late 2000s, we were focused squarely on the looming housing and financial crisis. The 2006 election had brought in a new House and Senate led by the Democratic Party. Oftentimes, when opposing parties control the presidency and the Congress, it is a recipe for gridlock, and even more so when that happens during a president's second term and in his final 2 years, while campaigns are being waged by both parties to replace him. But sometimes wins come in the most unlikely of places. In the midst of all that was going on, the work of government obviously continued. The House was considering patent reform legislation involving changes to our patent law, an endeavor that had been going on for nearly 60 years, and that was finally achieved with the enactment of the America Invents Act in 2011. But I'll get back to the AIA shortly. At the same time, Congress was also considering legislation to fundamentally change the US government's overall IP efforts. As various ideas were being considered, we began working with Chairman Leahy's team to craft a bill. The objective was clear. IP issues impact nearly every industry and every sector of the economy. Having a clear leader mandated to look at the overall picture, to coordinate across a broad range of cabinet departments with oftentimes divergent interests and priorities, and bring a White House-level perspective to the table was important. And this was not just important for Congress, but industry also made clear this was a priority at the very highest levels. In fact, during the financial crisis, President Bush invited industry leaders and CEOs to the White House to solicit their input and advice. It was during such a discussion that the issue of creating this new White House IP office was raised. So utilizing my draft EO, we laid out the overall structure for this new IP czar position. The legislation that Chairman Leahy, along with other members of Congress, and we all developed, ended up being much broader than the creation of the IPEC. We worked on enhancements to our civil IP laws, our criminal IP laws, as well as programs to expand resources and capacity building around IP. But even after gaining consensus for a good bill, the path to enactment was still treacherous, and we were in the middle of a global economic crisis. We were focused on housing and financial legislation. Getting an IP bill enacted, though a noble project, seemed unlikely. And we expected the legislation, much like my draft EO, would be filed away for another Congress in another time. But sometimes things are fortuitous. In the midst of housing negotiations on the Hill, members of Congress raised the importance of enacting a particular IP bill with Treasury Secretary Paulson. Immediately after this conversation, I was fortunate to talk with Secretary Paulson about the bill, and we decided to seize the opportunity and make it happen. President Bush signed the Pro-IP Act on October 13, 2008. That morning, Italian Prime Minister Silvio Berlusconi was at the White House for an arrival ceremony. And soon after that event, the President, pulling out a Sharpie from his jacket, signed the bill, enacting the Pro-IP Act into law. And fast forward to 2016, President Trump was elected, and during the transition, I was recruited by the President and Director Mulvaney to take on the IPEC role. After being confirmed by the Senate in August of 2017, I had the great honor and privilege to serve till January of 2021. Taking on this role that started from a draft idea in my desk drawer over a decade and a half ago to establishing as the newest component agency of the Executive Office of the President, the first in over a quarter century. I also served as the first Asian American to lead a EOP component in the White House. These are things that I think can only happen in America or Canada. During those 4 years, my goal was to strengthen and grow our nation's innovative economy, help promote our national and economic interests, and to advocate on behalf of all of our nation's innovators, artists, creators, and inventors. I'm proud of our international efforts, advocating for economic and business interests around the world. We consistently achieve tangible solutions to problems around the globe across a broad range of industry sectors. Domestically, we work to lead policy processes that ensured that sound IP policy prevailed. On the copyright and trademark fronts, we made great strides. For example, with the passage of the Music Modernization Act and the Trademark Modernization Act, the MMA provided critical updates to copyright law to reflect the realities of music licensing in the digital age and to better reward artists and producers for the online use of their music. And the TMA focused on addressing low-quality and fraudulent trademark applications at the Patent and Trademark Office to better protect legitimate brand holders. One of my final official acts in the White House was issuing the United States Joint Strategic Plan on IP. The statutory JSP is the product of input from industry, career government trade, national security, and law enforcement experts, Congress, and other interested parties. Similar to prior JSPs, it remains in effect across different presidential administrations, representing a comprehensive government-wide approach to promoting, protecting, and prioritizing our innovative economy. The JSP lays out a vision and strategy to set the stage for efforts going into the next decade by not just the United States, but countries around the world. For example, for industries like the automotive sector, the JSP lays out clear action plans to address counterfeit parts and supply chain issues. In the early 2000s, some of the big IP issues focused on optical disc piracy and the starting stages of patent reform. As the years have progressed, so have the issues, and the IPEC office is no different, handling a broad range of IP issues, managing not only interagency policy processes, but serving as a White House IP office providing key expertise and advice. As the Biden administration has implemented the Joint Strategic Plan on IP and deals with a host of novel issues in the IP arena, whether IP-related appellate cases, examining national security concerns, economic and innovation policy, or considering legislation, I am confident in the capabilities of the career IPEC staff and others within the EOP. But after more than 2 years, it was really great to see the President finally announce his nominee for IPEC this past Monday. Congratulations to Deborah Robinson on her nomination, and I wish her the best as she embarks on this incredible journey as the next IPEC. leading this White House component agency, advancing U.S. IP diplomacy, addressing the systemic problems in our IP system from issues including online piracy, counterfeiting, trade secret theft, and litigation abuse, and providing key policy and legal expertise on patent, copyright, trademark, and trade secrets for the EOP. With the time it takes to get a nominee through the Senate and into a desk at the White House, there is no time to waste. The issues that we face and the problems that we have to solve are simply too great. And so returning back to patent reform, the American Invents Act, has been in place for over a decade. The AIA was the first comprehensive reform to U.S. patent law since the 1952 Patent Act, and arguably the most substantial change since the 1836 Patent Act that created the very system of patent examination. I remember the day we introduced the bill, and I walked it down to the House floor to get it in the hopper and get the bill number, H.R. 1249. It was truly an exciting time getting that bill enacted. We had a lot of stories to tell from our work on the start of patent reform in the Bush years, the AIA's introduction, markup, floor passage, and enactment, to its continued implementation. But I won't have time to get into that today, and hopefully next time. But ultimately, the friendships that I made on both sides of the aisle, we showed that Washington can work. We had a Republican House that came in on the Tea Party wave, and a Democratic Senate and President. But we were able to work together and get that bill across the finish line. Not everyone got what they wanted, but on the whole, it was a bill that was built on consensus. It was written to help improve, update, and balance the system. For the most part, it focused on substantive areas of the law. It was written to protect small businesses and inventors from costly interference proceedings and to simplify the process for getting a priority date. Contrary to the opinion of some, the garage inventor generally does not have daily signed and witness notebooks documenting every day and step of their inventive process, ready to go in for what was then a costly interference proceeding. And as we watched the bill get implemented by the PTO, and as we've seen cases heard by the Federal Circuit and the Supreme Court, we can all see just how important IP is and how important it is that we follow the law and the Constitution. As someone who's been fortunate to be uniquely involved with most major U.S. IP bills that have gotten signed into law over the last several decades, I think that it's important that operations at the Patent Office be done fairly in a way that is consistent with the law. And that really isn't happening today. You've got too many bad actors gaming the system, not creating anything or building anything, just focused on getting a rate of return for investors who are bankrolling them. I've been fortunate or unfortunate to see these problems from both within government and now in the private sector. What we're seeing today is unique, and it's a problem that is damaging companies of all different sizes and all different sectors. This isn't how our economy is supposed to work. Intel was founded in 1968 at the birth of the information age, and we make semiconductors. Over the years, we've helped make Silicon Valley what it is today, developing new products, creating jobs, and always sitting on the cutting edge of the innovation economy. We've got several major factories in America, and we're embarking on a major expansion of our manufacturing footprint that will enable us to push our semiconductor industry forward, protecting America's future economic competitiveness and our technological edge. We directly employ almost 52,000 people in America, and our broader economic impact supports over 721,000 jobs across the U.S., adding over $102 billion to our GDP. We're also proud that Intel places in the top 10 annually in the number of patents granted by the USPTO. We want to make sure that we have a robust semiconductor industry, and we want continued investments in building out that infrastructure. Intel, like many in the technology and manufacturing industry, has been on the receiving end of this abusive patent litigation more times than most. It's critical that as innovators invest to build the next generation of groundbreaking technologies, we have a well-functioning IP system that is fair and reliable for assessing claims and fixing mistakes. Here in Canada, it's critical for the government to pursue policies and partnerships that incentivize job creation and economic growth. The expanding Albany-Bromont Chip Corridor is a fantastic example of the type of partnerships between industry and government that will grow the economy and create good-paying jobs. Additionally, it's encouraging that the Canadian House of Commons is studying how it can support the commercialization of IP. But it's just as important to ensure that we're not licensing just for licensing's sake, that we don't allow patents to be abused or manipulated. The end goal should be to actually produce something novel, contribute to economic growth, and ultimately create more jobs for the Canadian people. When we think about the patent system, we view patents as property rights. And when the Patent Office issues a patent, we'd like to believe that the office is only issuing one patent on one invention. The reality is that the office, more often than not, grants duplicative patents. There are many reasons for why this happens. For example, Each application submitted to the U.S. Patent Office receives on average just 19 hours of attention before a decision is made on whether it should be granted. As applications continue to rise, it is only reasonable to expect the folks who review these applications will be stretched thinner and thinner. Most of us here today have participated in enough discussions about patent quality to last more than a couple lifetimes. And as we look at the recent developments in our patent system, it's important to recognize that the lack of consistent quality in patents granted is the original sin from which many other problems stem, including duplicative patents. Imagine you purchase a house, you're handed the deed, and you're handed the keys. You think you own that house. What if the county issued deeds to someone else? How about a dozen someone else's? What if some of those folks file suit to have you evicted? How do you fix that? How do you make it right? Well, you'd hope that there'd be some process with the county or the state to examine those deeds and determine which deed is actually valid and which ones are not, and restore the rightful owner. Our patent system is designed to have similar quality control mechanisms with front-end examination, but also quality controls in the back end through director-instituted re-examination and the Patent Trial and Appeal Board. That takes us to the U.S.'s PTAB and the current issue of discretionary denials under the PTO's NHK FinTIV rule. So this is a rule that never went through proper notice and comment, and over the past several years, it's shown itself to be a creative way to arbitrarily force the PTAB to deny meritorious cases that otherwise comport with the statute. When we drafted the AIA, that one-year time frame for filing was important. We didn't want it to be completely open-ended. We wanted there to be sufficient time for meritorious filings to be made and heard. With recent changes made by the PTO, we've seen this rule's impact decrease, but it is still on the books, and it will be important for the office to ensure that, consistent with the AIA, that meritorious cases are heard. The USPTO's primary role is issuing patents and trademarks, and when there are challenges that make it likely that claims in a patent are invalid, then the PTO should absolutely fix its mistakes. In any instance where the Patent Office is aware that a patent that they have issued has problems, they have a responsibility to address it and ultimately protect the true inventor and innovator in the market. We must ensure that the government doesn't just view patent quality as something that ends once they hand out a certificate, but as a responsibility that is ongoing. And the same principles apply in the trademark side as well. When it comes to post-grant review, I know that opinions run hot on both sides, and there are some that would rather just have the Patent Office issue and have the court solely resolve. But that's not how our system operates. When the stakes are high, as they are in the patent system, it's important that the office balance speed of issuance with the ability to have experts at the office correct mistakes when they occur. We must be clear-eyed about the downstream impact of questionable patent quality in an environment where IP, and specifically IP litigation, is increasingly viewed as a lucrative investment strategy or as a way to surpass global competitors. This poses an enticing opportunity for bad actors to twist our patent system for their own financial gain, and even for adversaries to gain a competitive advantage. Outright intellectual property theft tends to draw significant attention, but the more subtle ways that poor quality patents allow some to take advantage of the system have flown under the radar for far too long. The volume of capital flowing into patent disputes in the United States shows just how large an opportunity investors think the area presents, and just how much the landscape of patent litigation has changed. In 2021, the third-party litigation funding industry had more than $12 billion in assets under management in the United States alone. That same year, patent litigation accounted for 29% of all third-party funding capital commitments, a 60% year-over-year increase. The influx of third-party patent litigation funding and litigation investment entities in which investors back lawsuits in exchange for a large share of potential settlements or awards has massive implications for our IP system at large. There are, of course, no uniform disclosure requirements for litigation investment entities, meaning that the entities who fund these lawsuits are often able to operate without defendants, judges, or juries knowing who is behind the curtain. This all results in more litigation and more expensive litigation and poses a direct threat to our national security, with foreign entities able to covertly fund lawsuits against their competitors or critical industries using the courts. Recent actions on disclosure by federal judges in Delaware, in the states of Delaware, New Jersey, and elsewhere have helped shine an important spotlight on this issue. An analysis conducted last year by Texas A&M University found that between 2015 and 2021, at minimum, almost 25% of patent lawsuits in the United States were funded by third parties. And when I say at minimum, it really means at minimum, because the lack of funding transparency in our courts allows many funders to operate unnoticed. The same study showed that NPs accounted for almost half of all patent cases over the same period. Analysis released earlier this year, just focused on 2021, showed a similar trend, with NPs accounting for 60% of all patent litigation and 30% of patent litigation being funded by third parties. Bottom line, the game has changed, and now we have to look to see how our institutions respond. Ultimately, our governments will decide on how best to keep our patent system modernized. I've stated on multiple occasions I believe we've always had a great IP system, but can things be improved? Can we continue to modernize and update our system? Of course we can. First and foremost, patents are property rights, and I believe in a strong and reliable patent system that enables us to invest in manufacturing, a system where we have better patents that are clear in scope, properly enabled, and give clear notice, a system where issued patents bear strong resemblance to their initial application. And that means that when guideposts are established in law, as Congress did with the America Invents Act, those guideposts should be followed, especially by the federal agency entrusted with them. Folks may disagree with the law, they may not like it, but ultimately, those are our rules of the road. And when we talk about promoting innovation, that conversation is not somehow the sole domain of those simply operating within the litigation ecosystem. Or better yet, just those who are leveraging settlement value on a company's castaway patents reaching the end of their shelf life. That's not what makes innovation run. The cycle of innovation starts and ends with those who are inventing, dreaming, creating, building, hiring, and developing our future. It is a conversation that includes patentees and inventors of all stripes, from those in their garages to those working in auto factories, research facilities, and businesses. It includes industries with operating companies ranging from biotech and pharmaceuticals, technology, transportation, and manufacturing. It brings together those that file for patents, those that are end users of technology, and even those that maintain it as a trade secret. And all of those categories are not mutually exclusive. Those who operate and implement also invent and conduct R&D. And policymakers will continue to weigh the costs and the benefits and determine what kind of economy we really want. I, for one, envision an environment where we maintain our technological edge and continue to innovate and build things. I'd like to see new jobs created, new factories, and more investment in R&D. From an economic competitiveness and national security perspective, we want to have a robust semiconductor industry, and we want continued investments in building out that infrastructure. It's critical that we get this right. We have to make our patent system better than it is today, not only to create new jobs, new factories, and more investments in R&D, but to protect our future. Ultimately, we should strive for a patent system that has better patents, ends litigation abuse, protects our national and economic security, and promotes that climate for innovation. Today, I wanted to present to all of you some of my experiences in the White House and on the Hill. There's much that has been done, but there is still a lot of work ahead of us, and that is why we need to continue working to protect our economic and innovative competitiveness, promote those new engines of growth, and prioritize our innovative and creative capacity. Thank you all. Great to see everyone here today, and I hope everyone enjoyed today's conference. Thank you.
That's what I want to ask you. If you can take some questions. I don't want nobody to kill me today. Donc, on a le temps pour 2 questions, peut-être 3, tout dépendant de la longueur des réponses. Donc, est-ce qu'il y a des personnes qui voudraient prendre l'occasion de poser des questions à M. Amin? Soyez pas intimidés, il est là pour vous. Et il ne sera pas là au cocktail. Donc, je ne sais pas si ça va vous aider à aller au micro, mais il ne peut pas rester pour le cocktail. Donc, c'est maintenant ou jamais. Going one. Oh, Monsieur Durand. Can you go to the mic? Mm-hmm.
Thanks, Vishal, for the great conversation. The question that I have is, there's been a lot of discussion in Canada about getting the innovation right, part of its policy. And one of the questions that we find ourselves asking is, how would one get SMEs or startups more excited about intellectual property? And what was the approach that the United States had adopted? And what would be a good takeaway or a few takeaways for the people up north?
So I think a big part of it is, it comes down to, investment in small and medium-sized enterprises in terms of, being able to have something that allows you to build that business. In the United States, we have a huge, venture capital industry. We have, a lot of, alternative financing for, a lot of those small businesses to, whether they're manufacturing or doing R&D. And so I think that's an area where there could be incredible growth. I know I talked to Ken earlier about this, but the Bayh-Dole Act in the United States, has been, an incredible sort of vehicle in terms of leveraging, the invention and R&D that occurs at our universities and allowing them to commercialize that. And I think figuring out ways in which, you're able to incentivize folks to have an eye towards things that can be actually commercialized, manufactured, things that eventually lead to job creation. I think that's the ultimate goal. And then in terms of, getting folks excited about doing research in those areas and, investing in those areas, I think that's going to be, that's probably the kind of the target area to look at.
Thank you. Another question? Going once, twice? Mr. Amin, thank you so much.
All right, thank you.